This is Newsroom. Hello and welcome from Johannesburg here in South Africa. I'm Evan Jansen. This show is live, broadcast from our studios in Auckland Park. We're also streaming live on YouTube right now with the whole show available on demand on our YouTube channel now. On our show today, we'll be back at the North Gauteng High Court shortly for an update on the appeals procedure for Oscar Pistorius. Also, we'll take a look back to yesterday at the Divani ruling at the Western Cape High Court, which has caused quite a stir on social media. Also, we'll look at a controversial ad campaign a little bit later and focus on the date rape drug Rohypnol. But first, the day's news with Katrine Miller.
Well, hello and welcome to Newsroom. I'm Katrine Milan, and let's just take a look at the top stories this morning. The state's application for leave to appeal Paralympian Oscar Pistorius' sentence and conviction is expected to be heard in the Pretoria High Court today. The state filed papers last month calling for a heavier conviction and harsher sentence to be imposed on the athlete. In the court papers, the state described the sentence imposed on him as shockingly light and inappropriate. The family of murdered bride Annie Divani says they'll never find closure to move on with their lives. Yesterday, the case against British businessman Shreen Divani was thrown out of court. Divani was extradited to South Africa in April to face trial, accused of planning the murder of his wife in November 2010. His acquittal ends a protracted trial and extradition.
The knowledge of not ever knowing what happened to my dearest little sister on the 13th of November 2010. That's going to haunt me, my family, my brother, my parents, for the rest of our lives.
The wife of slain South African teacher Pierre Korkie will be holding a press conference this morning. The conference follows the arrival of Korkie's body from Yemen also earlier this morning. Korkie was killed during a failed U.S. Special Forces operation over the weekend. His memorial service will be held in Bloemfontein later this week.
The family of Mr. Korkie has requested us not to divulge details of the arrival of the body because they wanted that to be in private so that they don't have a lot of media and public around the body when it arrives.
Eskom has issued a public apology for the ongoing outages in the country. The parastatal says it has no choice. It's either rolling load shedding or a complete collapse of the power grid.
What happened yesterday, unfortunately, was that things changed quickly. The outlook had been good for the week, and unfortunately at the Majuba power station, the cables which were supplying the mobile coal conveyors, which were taking coal into the Majuba power station following the site of collapse, those cables were damaged during the repair work, which meant that we basically once again lost the capacity from the Majuba power station. We apologize again for the lack of communication. I think the communication at the time was correct, but a couple of hours later, of course, the incident happened and once again plunged us into darkness. So we apologize for that.
And non-profit organisation Right to Care is recruiting South African healthcare workers to help with the Ebola outbreak in Sierra Leone. The organisation is looking for doctors and nurses with ICU experience and willing to work in Sierra Leone for 3 months. Meanwhile, junior doctors in Sierra Leone have embarked on a strike to demand better treatment for health workers who become infected with Ebola. The association representing junior doctors has asked the government to make sure life-saving equipment such as dialysis machines is available to treat infected doctors. Well, remember, all those top stories and more are available on our Newsroom Facebook page. You can then also keep up to date and follow us on Twitter at SABC Newsroom. Evan, over to you.
Thank you very much, Katrine. The National Prosecuting Authority believes there exist reasonable prospects of a successful appeal based on the question of law against the conviction and sentencing of Oscar Pistorius. The Pretoria High Court will today hear a request to appeal Pistorius' manslaughter conviction and 5-year prison sentence handed down by Judge Thokozile Masipa in a marathon trial that lasted over 7 months. The NPA has described Pistorius' sentence for killing Reeva Steenkamp as shockingly light and wants a tougher sentence. The jailed Paralympians legal team has opposed the move for an appeal. setting the stage for a hearing before the North Gauteng High Court. Under South African law, the double amputee could serve just 10 months in jail. Now, for a quick update, let's cross to our reporter, Griselda Lewis, who's been covering this trial throughout. Good morning, Griselda.
Well, a very good morning to you, Eben.
It's not over yet. We're back at the High Court. Just tell us the expectation and the latest, if there is such a thing today.
Well, certainly, Eben, we're back at the North Gauteng High Court, where the state will hear if Judge Thokozile Masipa will grant leave to appeal the conviction and sentence in the Oscar Pistorius trial. We've heard from day one that the National Prosecuting Authority was not happy, saying that basically the time that Oscar Pistorius was given behind bars does not fit the crime. They're calling for a harsher sentence, saying that Oscar Pistorius should be jailed for murder, saying that Oscar Pistorius did know what he was doing when he pulled the trigger 4 times on that Valentine's Day morning. Now, on that application, some of the crucial aspects that the National Prosecuting Authority puts across is that Judge Thokozile Masipa did not apply her mind and that she misinterpreted the law when she ruled that Oscar Pistorius did not intend to shoot and kill Reeva Steenkamp. What the state is saying is that Oscar Pistorius knew very well who was behind that door, and that Oscar Pistorius didn't fire just but one shot. He fired 4 shots, and that Judge Thokozile Masipa should have taken all of that into account. So it's a question of law that the state would want to put to Judge Thokozile Masipa here this morning.
Oscar Pistorius will not be at the court this morning. Is that accurate, Griselda?
Well, even it's very difficult to tell at this point. There is speculation that Oscar Pistorius might be at court. There's speculation also that he might not be here this morning. But what we're hearing from some of the legal experts is that if Oscar Pistorius does pitch at court, that would be the hope then that the state is successful in this appeal process, and that Oscar Pistorius would be given the opportunity then to reapply for bail, of course giving then the defense team enough time to be able to prepare its case, which if Judge Thokozile Masipa, of course, does allow the state to leave to appeal, that means then that this case would go before the Supreme Court of Appeal only before sometime June next year.
What are the legal experts saying? What are the facts that the NPA will be basing this appeal on today?
The crux of the matter at this stage, Eben, is the fact that the NPA is saying that Judge Thokozile Masipa in the first place should not have found Oscar Pistorius guilty of culpable homicide, yet a harsher charge in that of murder. That is what he should have been found guilty of. Certainly the culpable homicide charge then, where Judge Thokozile Masipa said that she found that Oscar Pistorius was negligent when he pulled the trigger, meant that Oscar Pistorius then was going to be given a sentence certainly much lighter than what he would have received had he been found guilty of murder. So what the NPA is saying is that given all the facts that Oscar Pistorius knew the rules relating to the carrying of firearms, when to and when not to discharge a firearm, and the fact that he was supposed to know who his target was behind that door, the fact that he fired 4 times and not once, the fact that Oscar Pistorius, for example, several other issues that they had put together in this application, saying that on the question of law, Oscar Pistorius knew what he was doing. He acted with intent, but you must remember Judge Thokozile Masipa found otherwise. So they really want to drive home a point across this morning that would indicate or try to sway Judge Thokozile Masipa into believing that Oscar Pistorius did intend to shoot and kill Reeva Steenkamp behind that door.
Griselda, I see it's rather quiet there behind you this morning. It looks like media interest or speculation has completely disappeared in a way. But tell us about that, and also what are the media then speculating about the last couple of months of the incarceration of Oscar Pistorius? Has it been a lot of tears in jail, or is he adapting to life?
Well, it's very difficult to say how Oscar Pistorius is doing behind those correctional services bars here, but certainly one interview that was that Carl Pistorius, Oscar Pistorius' brother, had granted to one of the local magazines. He'd basically said in that magazine that Oscar Pistorius was taking each day as it comes. He was not receiving preferential treatment, and they were basically relying on the number of visits that there are allowed at the correctional facility. But it's very difficult to say at this stage how Oscar Pistorius is doing. But certainly it would be a significant shift from the luxury life that Oscar Pistorius had been accustomed to being behind bars, not having total freedom, in comparison to the celebrity and praise that Oscar Pistorius had been accustomed to during his glittering career.
Griselda, thank you very much for that update outside the North Gauteng High Court. That is our reporter, Griselda Lewis. She's been on the Oscar Pistorius trial, well, since the start, really. But the man who needs an introduction here in studio with us is a legal expert or law expert, Elton Hart, from the University of Johannesburg's Law Clinic. Good morning, Elton. Thanks for joining us.
Good morning, Eben, and thanks for having me on the show again.
Busy, very high-profile day in the courts yesterday. Devani will get to that a little bit later. But let's talk about Oscar quickly. Dolus eventualis, is that the principle that's before the High Court today, or how do you read it?
Yeah, but if I look at the situation at this point in time, it's like the prosecution is now appealing the sentencing and also the conviction of Oscar of culpable homicide. And the thing is, like, the judge has to now look at the evidence again and see, is another court going to find a different way than she did? So it's more a question of law. The facts was put before court, the evidence was put before court. So the prosecution cannot come now and try and introduce new facts or evidence to say the court must look at it differently. They must work with what they put in front of court, because that was the only thing that the judge had to work with in the first place. So they cannot now ask her to go outside the boundaries of what they placed in front of her. And people might say that she misinterpreted the law, but based on the evidence, that's the only thing. And I think the state, there was a threshold that they were supposed to meet, and they didn't meet it. And that's why the judge had to apply the law and move to culpable homicide, because according to me, they didn't show that Oscar had the intent to kill, which everybody is screaming murder, murder. But culpable homicide is then the competent verdict, and the judge has then to go to a culpable homicide.
So it won't be another lengthy court battle that will play out after today?
No, necessarily it won't be a long, lengthy court battle, because the notice of appeal is served on the other parties. They have seen the papers already, and basically what the judge looks is it's just papers that's in front of the judge. The judge looks at the papers because the arguments is set out in the papers already. There might be one or two issues that the judge might ask the respective legal representative for state or the defense to just clarify. But she has been involved in the trial. She knows what's happening in the trial. And obviously the notice of appeal was served on her long before, so she knows what is the points that state is going to bring and what is the points that the defense is going to bring for their appeal to succeed or to fail.
The one thing that's been in the media the last week or so has been this based on fact and based in law. Mm-hmm. Can you explain to us the difference between those?
Based on fact and based on law, because the facts is like, if it's the cold facts of the case, what the investigators put in front of the prosecutor to actually present to court. That's the facts. And that facts is the facts that, and then the prosecutor tried to prove certain facts that was on the docket. And the facts that has been proven, that's the facts that the magistrate or the judge in this case works with. So, and then the question of law will come in where the magistrate or the judge has to now interpret the differences between dolus eventualis, dolus directus, those type of doluses that was all over the media the whole time. Yeah. And that is the application of law. So the facts is what the investigators put before the prosecutor to present to court as evidence. Mm-hmm. And after that facts has been proven or not proven, disproved, then the magistrate or the judge has to now move into the application of the law as to say what is right in our country and what is the legal principles that we have to follow. If this threshold hasn't been met, what type of verdict I am supposed to bring out.
If leave to appeal is granted today, just tell us the process then that will follow.
Leave to appeal if it's granted, then obviously the matter will go to the SCA, or you can also get leave to appeal, and then, because there was now one judge sitting on the matter with 2 assessors, you can also have 3 judges sitting in the High Court looking at the matter. So it can go from 1 judge to 3 judges to actually listen to the appeal, or if they prefer that way, they can actually move it to the SCA, because I think the NPA, in bringing this appeal, well, they also want to set legal standard, because people were having this outcry and saying that this type of sentences is not in the interest of justice, and it makes our legal system look like a palooka system. So that also, they might just bring it to the SCA, and if the SCA gives judgment on a specific aspect as a principle of law, then all the courts is bound by that. So whatever a judge do in future, they need to look at a decision from the SCA. And I think that's most probably what the NPA is trying to do, to bring it to the NPA to the SCA, so that they can actually get clarity on the matter, and then we have a legal standard as well.
Now, interesting that you talk about the South African justice system and the image, and you talk about a palooka justice system. Another interesting case yesterday, of course, was Shrindavani's case. I'll ask you to stay with us, because I just want to cross to our report in Cape Town and then get your opinion on that, because there's been a lot of social media traffic around this case. Of course, Vanessa Puna has been covering this story. We all know now that Shrindavani, the British businessman, he's a free man. The Western Cape High Court Judge Janet Traverso has thrown the Shrindavani murder case out of court. Davani's lawyers had approached the court to ask for a discharge in terms of Section 174 of the Criminal Procedures Act. She said that the state's witnesses had contradicted one another. He was charged with kidnapping, murder, and then defeating the ends of justice. It was alleged Davani plotted with taxi driver Zola Tongo and others to murder Annie Hindoka in November of 2010. The judge then found Davani not guilty of the murder of his new bride. Now, Vanessa Puna, as I said, has been on this case right from the beginning. She's in our studio in Cape Town. A very good morning to you, Vanessa. Thank you for joining us.
Good morning, Eben. Thank you.
It was a polarizing verdict in many ways. Were you surprised by what happened yesterday, and what's the word on the street amongst the acts?
Eben, no, I don't think that yesterday's ruling came as a surprise to many of us sitting throughout the trial in the Western Cape High Court. We've heard from various legal experts from the time that Zola Tongo took to the witness stand to the various other state witnesses that have been called, 16 in total, in this murder trial. And it was sort of easy to gauge once the defence brought the 174 application, more or less which way the judge could possibly go. Now, not saying that we're legal experts at any stage, but it was quite easy to tell, to lean toward a certain way that the judge would rule. Lots of public outcry yesterday. We've seen outside the court people very vocal in their disappointment, calling for justice for Annie, saying that justice has failed her. Family speaking on the steps of the High Court yesterday, saying that they have more unanswered questions now than that they had 4 years ago when her body was found slumped in the back of the shuttle taxi in Khayelitsha. So, yes, lots of public outcry on the social media as well. People not very happy with the judgment of Deputy Judge President Janet Traverso. But what is interesting, the judge yesterday spoke to the Ndorcha family from the bench when she said that she's not blind to the emotion, to their calls for justice for their daughter, but that as having taken an oath as a judge, she cannot be swayed by public opinion and emotions, that she has to go on the facts before her. And I've listened intently just now to Alton, also talking about what the judge has to consider. In this case, in the 174 application, it wasn't as much as the credibility of the state witnesses, but rather the quality. Could the judge possibly, or could any other court come to a different conclusion based on the evidence before the court? And Judge Janet Traverso said yesterday in a ruling that the quality of the state witnesses, also, bear in mind, most of them accomplice witnesses, was of such poor quality that no other court could come to a different finding. So Shrindavani, a free man today.
Just talk us to the emotion afterwards. A lot of people are pointing fingers now at the NPA for this long and drawn-out extradition process at great expense to the South African taxpayer, without proper and credible case against this man. What's the reaction towards that this morning?
The reaction from the NPA when we spoke to them yesterday as well as this morning is that they could not go ahead with a prosecution in this matter based on the possibility that there could be an acquittal sometime later down the trial. The NPA says that there was a prima facie case against Sri Ndavani. This led to the UK courts extraditing him to South Africa after a very long and protracted legal battle. At the end of the day, there's also been talk about the quality of the police investigation. A forensic expert early on in this trial came out, guns blazing, saying that it was a shoddy police investigation, saying that the state did not have enough to work with to convict Sri Ndavani because of various aspects of a failed police investigation. Lackluster, I think the word was, that was used. At the end of the day, I've also heard from various other legal experts that justice has been done because the judge in this trial and in most other trials can only work with what is presented before her. The judge yesterday described the accomplice witnesses Zola Tongum, Zomadoda Kwabe, as well as hotel receptionist Mondi Mbolombo as self-confessed liars, versions changing from first, second and in some instances third statements to police, their versions changing when they came into the witness stand to testify against Sri Ndavani. And the judge said that she can only go on this evidence presented before her.
And the reality is it was a shoddy case. You mentioned shoddy police work, the focus being squarely now on the South African justice system, especially after the very, what was seen as a light sentence in the Oscar Pistorius trial. How are we being viewed and how are our police investigations being viewed now, if this is the case in these high-profile cases?
Eben, there has been calls for the police to step up. I know that there's, just here in Cape Town not too long ago, a commission of inquiry into policing in Khayelitsha, for example. Evidence brought there before that commission pointing to various loopholes when it comes to the various aspects of policing, from training to policemen taking statements, what happens with case dockets, etc. So policing has come into the spotlight at that commission of inquiry. And again, I think yesterday with the judgment in the Sri Ndavani matter, there have been calls for the police to step up their investigation, to step up the training of investigators, forensics people, etc., etc. But then also questions about why would the NPA then take this matter, go ahead and prosecute when, there's not a winnable case, which they say they can't, just because there could be acquittal or just because the judge could find against the state, decide, oh, no, we're not going to go ahead and prosecute in this matter. So there are various feelings on the ground around where the fault lies. But at the end of the day, I've also heard comments that justice has prevailed, that South African justice system works on the basis of the judge will decide on the facts before her in a court of law. And this is what happened yesterday when she made this ruling. Interesting also, Eben, if I can just talk about the sidebars, there have been inquiries about where Sri Ndavani is. Has he left the country yet? We have made contact with the British High Commission to ask whether Mr. Ndavani has indeed left South Africa yet. You'll know that even yesterday I tried to get comment from his brother, from his mother and father, and they've steadfastly refused to speak to the media throughout this trial. Once again yesterday, they would not grant any interviews. The British High Commission has also told me that they can't comment on the travel plans of the Ndavani family. So at this point, it's not clear whether Sri Ndavani has indeed left South Africa or not, but we do know that there have been media requests to the airports company, for example, to come and film just in case Mr. Ndavani leaves South Africa. Also interesting to note that the Justice Department yesterday said that they will not be transporting Mr. Ndavani back to the UK. You'll remember that he was brought here when he was extradited on a private jet, but they now say that he will have to pay his own and find his own way back to the UK after the judgment in the High Court yesterday.
I'm sure Mr. Ndavani would not... He wouldn't be too worried about paying his flight ticket back. Thank you for joining us today, Vanessa. Vanessa Puna has been, at length dealing with the Ndavani trial over the last couple of months, and she's done a fantastic job. Now, I've still got Alton Hart with me from the University of Johannesburg's Law Clinic. Before we get into the Ndavani case, just tell me the similarities that you see between this case and the Oscar Pistorius case, and how do you view the way our justice system handled this?
The only similarities that I see between this case and the Oscar Pistorius case is like the lack of proper investigation into the matters. And in the Oscar trial, there were certain discrepancies that the investigators didn't clear up. They didn't look at certain evidence. They didn't explore other avenues to see if there's any other possible explanations for the evidence that they have gathered. In Shirin's case, in the Devani case again, same thing happened. The evidence was gathered, and again, they didn't look at how is the witnesses going to testify when they are put on the stand? Yeah. Were they properly prepared? And what I'm saying is not that you have to coach the witnesses now as to what to say, but you need to test in a robust way what they're going to say on the stand.
We then had acting classes in the Oscar trial. What do you talk about not coaching the witnesses? Isn't that standard practice amongst you lawyer people?
No, but we don't coach the witnesses. It's unethical to do so, to actually tell the witnesses what to do. You just need to test them. And it's like testing is like you'll run a mock trial in your office, putting questions to them. Okay, so you do coach them then. Let's leave that one out. And quickly, before you go, this case has been thrown out of court because the case is so poor. So there won't be any appeal with it. No, the thing is, it's thrown out of court. 174 means that he has been discharged. So they can never, ever bring those charges again against Mr. Devani, ever again. So he can come to South Africa as many times as he needs now. He doesn't need an extradition order to come to South Africa anymore. Well, we welcome Mr. Devani back, because if you are proven to be innocent in front of the court, then that is the case. And that's a reality. Thank you for joining us today. Alton Hart from the University of Johannesburg's Law Clinic, giving us his views on both these high-profile cases. But what are your views? Well, on Twitter, there have been lots of views the last couple of days. At SABC Newsroom, here are some of the ones. And Paul says, so in South Africa, if you kill a person with a Mini Cooper like Jub did, you go to jail. And if you hire hitmen like Devani, you get away. That's an interesting view. Guilty Pleasure says, it took SA Justice 4 years to get Devani here, but still managed to get it wrong. Fail. Michaela says, I've learned this year from Devani and Oscar Pistorius that justice is only something for something the rich can afford. Remember, justice is blind. Unlike us who walk the streets, justice is blind. Jacques Spiss says, Devani free. Watch how his mental illness is now cured. I saw him, yes, he's starting to get a bit of colour back in the face there. Alfreda Sebakeng says, Devani court ruling, this is the reason why people take the law into their own hands. What's the point when the justice system fails? The justice system is the same for everybody. Justice is blind. The onus is on the state to prove beyond reasonable doubt that we or the person in the dock is guilty. Otherwise, many, many innocent people will go to prison, and that's not something that we want. But let's take a look at the front pages from around the globe this morning. In the United Kingdom, the Daily Mirror has a heartbreaking picture of Annie Devani's family on the front page there. This was taken after British businessman Shirin Devani was cleared of murdering his wife Annie during their South Africa honeymoon in 2010. In the United States, the New York Post says the city has welcomed Kate and William, the Duke and Duchess of Cambridge, academy in the U.S. to put the spotlight on the illegal trade of wildlife. And you'll see that other papers from around the globe are looking at that same story. There, the royal couple were pictured arriving at the Carlisle Hotel. Before we go to an ad break, let's just have a look at what's happening across the country today. In Pretoria, Stats South Africa will release mining production and sales stats for October. Stats SA will also release the manufacturing production and sales stats for October. And then in the Eastern Cape, in Bizana, the bail application of 3 people who face charges of arson in connection with the burning of ANC stalwart Oliver Tambo's statue will also be heard. You're watching Newsroom. We will be back with you shortly.
I realized Life is short. I want to live my dream.
They can bang my face, but not my voice.
I'm definitely not a cross-dresser. South Africa, I'm just a gay man.
Join Puleng Molebatsi on Bupilong every Saturday at 17:30 CAT. Zoom into Africa. This is Eritrea. The president is Mr. Isaias Afewerki. Eritrea got independent from Ethiopia on 24th May in 1993. The population is over 5 million people. One of the major languages spoken is Arabic. Monetary unit is the Nakfa.
Hello and welcome back. You're with Newsroom on SABC News. Let's just take a look at the morning's top stories. The state's application for leave to appeal Paralympian Oscar Pistorius' sentence and conviction is expected to be heard in the Pretoria High Court today. The state filed papers last month calling for a heavier conviction and harsher sentence to be imposed on the athlete. In the court papers, the state described the sentence imposed on him as shockingly light and inappropriate. The family of murdered bride Annie Devani says they'll never find closure to move on with their lives. Yesterday, the case against British businessman Shreen Devani was thrown out of court. Devani was extradited to South Africa in April to face trial, accused of planning the murder of his wife in November 2010. His acquittal ends a protracted trial and extradition. And the wife of slain South African teacher Pierre Korkie will be holding a press conference this morning. The conference follows the arrival of Korkie's body from Yemen earlier this morning. Korkie was killed during a failed U.S. Special Forces operation over the weekend. His memorial service will be held in Bloemfontein later this week. Remember, all those top stories and more are available on our Newsroom Facebook page. You can then also keep up to date and follow us on Twitter at SABC Newsroom. Eben, back to you.
Thank you very much, Katrine. Last week, 2 men were arrested in Johannesburg for the possession of more than 12,000 Rohypnol tablets. Now, for those that don't know, Rohypnol is commonly known as the date rape drug. It's been banned in countries like the United States and India, but remains a prescription drug here in South Africa. Now, to talk to us about how the availability of this drug is regulated, we are joined today in Pretoria by the Medical Control Council's Deputy Director of Law Enforcement, Mr. Griffith Malawa. Very good morning to you, Mr. Malawa. Thank you for joining us.
Good morning.
Mr. Malawa, just tell us about the availability of Rohypnol here in South Africa. What schedule prescription drug is it?
Okay. Rohypnol, the active ingredient thereof is called flunitrazepam, is a Schedule 5 prescription drug medicine. What it means is that now, for a person to be in possession of that medicine, that person has to get a prescription from the doctor and then take it to the pharmacist, and the pharmacist will dispense it. And the pharmacist will then complete a register with the patient's name, the quantity, and the product name, which was dispensed, and then balance the books to say, now, after dispensing this product, how much do I still have?
How do you at the MCC manage the, if there is such a thing, policing of these kinds of scheduled drugs?
Okay. What's happening, the functioning of so-called policing, it's a Department of Health function. What we normally do, once a product has been registered by the MCC, with the Medicines Control Council, then the law enforcement unit, which is an equivalent of a compliance unit, will have to ensure that now the distribution, the selling of it, the manufacturing, the warehousing of it is properly controlled in the controlled channels. Because remember, the manufacturer has to be registered, the wholesaler has to be registered with MCC also, And the pharmacy has to be registered with the Pharmacy Council and the doctor with HPCSA. So that's how we control, we make sure that now it doesn't go out of that distribution channels. But further than that, now when you look at again now, because now South Africa, we don't have most of the manufacturing plants which they are situated overseas. When the company like Roche, the manufacturer of Rohypnol, will have to import that product, and that product can only come through dedicated port of entries, which are 7 at the moment. I mean, South Africa, we have about 52 entries, land border entries, and we've got about 10 airports. But of those numbers, we have chosen only 7, and those 7 will be Cape Town, Port Elizabeth, Durban, both A and C, and OR Tambo. So that makes it 7. Anything that's coming into South Africa, other than those products, should be confiscated. That's how we try to now control the movement of that drug into South Africa.
Tell us then, if these scheduled drugs are being managed so carefully, how do 2 men arrested in Johannesburg last week end up with more than 12,000 of these pills in their possession?
Okay. Remember what I've said earlier. I said now we have about 52 land border of entries. And now what would normally happen, they might come through one border but not declaring the product. And that is only now, this was possible because of the vigilance of the border control personnel. But in most instances, we find that now the border control personnel is not that vigilant, and people would come through into the country with such concernment.
Tell us about this, the drug and the sentence that goes with it. If you get caught with, say, a large amount, like what is in this case, of this date rape drug, what type of sentence are you looking at right now in South Africa?
Currently, the law prescribes that now any person who's caught with drugs like this, Rohypnol, will get either a maximum of 10 years and or a fine. Now, depending on how the case is being presented before the courts, and that's how we will terminate.
Mr. Malewa, the problem that we have in South Africa is that we have unscrupulous people who go into clubs and drug unsuspecting people, both men and women, and have their way with them, whatever that might be. Will the person who goes out with a small amount to drug and rape or do whatever they want to do with people, will they ever be caught, and will that process ever be managed?
Like you said now, it's unscrupulous people. We also have unscrupulous professionals. I mean, doctors, pharmacists, you name them. And depending on the source, I mean, like these 2 people who are caught, they will distribute it. And if at all don't get the source, then it becomes a bit difficult to really catch those people. But if at all those people are caught, the ones who go to the clubs, clubbing and everything with those small quantities, that will leave it to the police to invoke now the Criminal Procedures Act and deal with them accordingly. And remember also, let's not forget now, that Rohypnol also is a scheduled substance under the Drugs and Drug Trafficking Act. So that's why, hence I'm saying now the police now will have to invoke also that act to charge that person, irrespective of the quantity, whether it be 2 tablets or that other thing. As long as that person cannot prove that he or she has a prescription for that particular medicine. And you have to say now where he or she got it from.
Yeah. Well, Mr. Malewa, thank you for joining us today. That's the Medical Control Council's Deputy Director of Law Enforcement, Mr. Griffith Malewa, join us live from Pretoria. We're talking about the scourge of date rape drugs that's all over South Africa. Men were caught with 12,000 tablets here in Johannesburg last week. Don't take drinks from anybody. Buy your own drinks. Let's have a look at your tweets. What do you say? At SABC Newsroom, why they call you says, Miss Corky is a good woman though. That lady and her kids deserve to see their dad and husband again. Thoughts and comfort to the family. Yes, there will be a press conference at 12 o'clock today by Yolanda Korkie. Basetsana says, my heart goes out to Korkie's family. Yes, I think everyone's heart goes out to the... Sibabawa says, some failures are a bit too much. US not only condolences, own up as well. Those are some of your views. What's on our Facebook page? Let's take a look what's happening there. Today, you'll see there on our Facebook page, the South African Chamber of Commerce and Industry says government should urgently review its energy policy. This, as Eskom has been backing with supplying electricity due to ongoing technical failures. Then, Transnet's National Ports Authority has admitted that it will take a while before fuel supplies are fully restored in Port Elizabeth. The statement comes after motorists began queuing at fuel stations around the city as pumps ran dry at the weekend. And the National Prosecuting Authority says while it is disappointed with the discharge of Shrindavani, it is relieved that it has succeeded in the conviction of 3 men linked to the murder of his wife, Annie Devani. You can find all those stories and a whole lot more on our Newsroom Facebook page. You can also visit us, sabc.co.za/news for all the latest updates. Time for us to take a short commercial break. Newsroom will be back right after this.
Cameroon's economic capital, a unique art collection is on display. Titled Yesterday's Memory, Tomorrow's Memory.
We are trying to preserve this heritage despite many things that have changed in the designing, embroidery and the model.
If I'm telling you, you don't like it, I call it defeat.
Join Musam Khalipi on Afro Showbiz every Saturday at 19:30 CAT. Zoom into Africa. This is Comoros. The president is Mr. Ikilulu Dwanine. Comoros got independent from France on 6 July in 1975. The population is over 700,000 people. One of the major languages spoken is French. Monetary unit is the Comoran franc.
Welcome back here with Newsroom. South Africans have become all too familiar with the First National Bank phrase, don't be a Steve. But while some may love the campaign, many seem to have taken offence to it. After about 20 complaints were lodged against the campaign, the Advertising Standards Authority ordered the bank to un-Steve itself last week and to withdraw all the advertisements. Now, to talk to us a little bit more about this, we are joined in studio today by the Advertising Standards Authority of South Africa's CEO, Thembi Msibi. Very good morning to you, ma'am. Thank you for joining us.
Thank you for inviting us.
Just give us your thinking around ordering the un-Steve yourself ads to be withdrawn.
There were two aspects to the complaint. One dealt with just people, adults, taking offense at it. The other one dealt with children, in terms of children being harmed. Some parents who have little boys named Steve complained that their children are already being teased at school by the name, because they have the name Steve.
Steve, yes.
So when we looked at it, we had to look at offense, we had to look at discrimination, but particularly we also had to look at children. And on the offense and discrimination, this is towards the adults. We dismissed that. We said, you can differentiate. We know adults can know that this is not the Steve. They know this is just about any Steve, and it is selling service of the bank. So on those two aspects, we dismissed it. However, when it came to the children, we had a bit more difficulty. And our code, of course, has a clause 14, which provides that advertising should not harm children, be it mental, physical, emotional, or morally. So we had to look at that. And further, it says our code also provides that advertisers should prepare advertising with a sense of responsibility to the consumers.
Yeah.
When we looked at those two and basically what was happening with children and the fact that children can't differentiate, whereas adults can differentiate that we're not talking about the Steve that we know, children would not necessarily differentiate, and they may think that it's okay to ridicule Steve as is being done on the ad.
Yeah.
So that would cause harm to other children. So that's where we ruled against the ad and indicated that it has to be amended or withdrawn in its current form.
So it wasn't Steve Hofmeyer who was complaining to the ASA about this campaign?
No, it was not Steve Hofmeyer.
No, I wanted to talk to you, ma'am, about some of the other... We've got a very vibrant advertising industry in South Africa, and some other big companies they name people and they pick up things in the news and in the media and so forth, and are not afraid to target individuals and so forth. Do you only deal with these kinds of scenarios when there's a complaint or when there's many complaints, or do you take a more proactive approach?
No, the way we're established, we take a reactive approach. So somebody has to complain to us. And it does not matter whether it's one complaint or a number of complaints. Immediately we receive a complaint, we first assess it, whether there is likelihood that it breaches the code. If we find that there is, we then go on to investigate. So the numbers don't necessarily matter. At times we found that we've had quite a number of complaints, but we've actually found that the ad is fine. So the numbers for us is not a major issue.
In conclusion, ma'am, just as the Advertising Standards Authority of South Africa, what is your message then to private individuals and the public sector even with regards to advertising?
Well, you basically, if you're going to put together an ad, you need to ensure that you're conversant, or at least partly conversant with the code of advertising.
Well, ma'am, thank you for joining us today. That is Thembi Msibi, who's the CEO of the Advertising Standards Authority of South Africa. Thank you. Thank you for joining us. Well, we were going to look at some of your views, but we can't because the North Gauteng High Court has just started. Of course, it's the appeals procedure today with Oscar Pistorius' trial. Let's go straight to the North Gauteng High Court.
Use of firearms, there's a high degree of responsibility in the use of firearms is required from such a person. We're not dealing with a person that just grabbed the gun and fired. We're dealing with a trained person. And then, my lady, we incorporated in our heads the list in our application for leave to appeal. My lady, then, may we deal with mercy? My lady, I argued mercy, and I'm not going to re-argue mercy, but I understand mercy. It's crystallized all over sentences that the court will have some mercy. My lady, but there could also be an instance, and I say this with the utmost respect, where too much mercy is shown to an accused. Because, my lady, if one take into account everything that was just said, that the court summarized, then the court said, but the court correctly said that an appropriate sentence should include an element of mercy. Now, my lady, if that mercy is that the court would say, I think that the suitable sentence is 10 years, but now I have to be merciful, now it goes down to 5. Then clearly, my lady, that would be a misdirection. My lady, if I read the judgment, and I say it with the utmost respect, if I read the judgment, the court said that because of everything, because of the consequences, because of his actions, because of gross negligence, sentence, a non-custodial sentence is not appropriate. And then the court applied the mercy principle. My lady, based on all the facts, we say that perhaps the element of mercy was over-exaggerated. And we quoted at page 11 of our heads, my lady, where the court said a non-custodial sentence would send out the wrong message to the community. On the other hand, a long custodial sentence would also not be appropriate, as it would lack an element of mercy. Now, my lady, what we're saying is, if the court would ask me what I think a long custodial sentence would have been, I would have said 10 years, my lady. Now, if it is 10 years and this accused ended up, when mercy was applied, with 5 years in terms of 276, I respectfully say that was a misdirection. Because, my lady, although the court said that a non-custodial sentence would send out the wrong message and that an element of mercy should be applied, the court then imposed the shortest reasonable period of incarceration that the court would be able to do. And I say reasonable, my lady. I've really tried to think what other sentence of incarceration would have been less lenient than 10 years, my lady. 10 months, my lady. And nothing comes to the fore. Except because the court wanted the element of custodial sentence to be applied, my lady. Did the court want the shortest possible period for gross negligence and what's the other word? Gross negligence and actions bordering on dolus eventualis to be applied to. My lady, we say that with the utmost respect to the court, a court of appeal, having had regard to the way the court dealt with sentence, the way the court summarized correctly, my lady, the way the court summarized what the accused did, that we have no problem with. We agree 100% with that. But if that is applied to the end result, which is the shortest possible incarceration, then, my lady, it's shockingly inappropriate. And we say that, my lady, we say it's shockingly inappropriate. My lady, I do not have to convince this court that it's shockingly inappropriate. I, however, say that there is a very good prospect that we may convince the appeal court that the shortest possible period of incarceration in a situation like this, my lady, is shockingly inappropriate. And therefore, my lady, we say we've made out a good case for leave to appeal on sentence. May I proceed with 319?
Yes, you may.
Lady, and again, as far as 319 is concerned, we filed heads. As far as Section 319 is concerned, my lady, there are a few hurdles that I have to cross. I'll mention them all and acknowledge them, and I will deal with each one. The first one, my lady, is the Siekwe hurdle. We will deal with that. The second hurdle is the question that should be reserved for the Supreme Court of Appeal. I see the Act wasn't changed. If one reads 319, it still refers to the appellate division. But I mean, I think we all understand that it's now the Supreme Court of Appeal. That it should not be merely an academic question. It should be a question that, if answered in the affirmative, would have an impact on judgment. Third hurdle I have to cross, my lady, is that are we dealing with a legal or factual question? And then, my lady, those are the hurdles I have to cross. The things I will discuss and will make submissions to the court where we feel that the court may have erred, my lady, is the application of dolus eventualis to the facts of the matter, and particularly, my lady, where to the where the court found that accused acted with putative self-defense, particularly there, my lady. We will address that and say that the court erred in applying the principles of dolus evincialis. We will continue, my lady, to say that the court erred in not taking into account, as the court should have, all the circumstantial evidence that the state presented. And, my lady, with the utmost respect, that the court, in dealing with circumstantial evidence, applied the principle of evaluating each piece of circumstantial evidence in isolation. And the court did not, as the court in 44 Appellate Division de Villiers said, that one should look at the circumstantial evidence as a whole. My lady, we say that in this particular instance, with utmost respect, my lady, that the court did not do that. This principle was, we tried to argue a mosaic. In the past, my lady, it was said that a piece of circumstantial evidence is but one feather on the scale, and lots of circumstantial evidence will weigh much more than one particular one, and to take that off and to weigh the next feather and take that off the scale and to weigh the next feather. And then, my lady, we will, with utmost respect, argue that the court erred, with respect, my lady, in finding that the accused version was reasonably possibly true, because the court rejected his version. He had a version, an elected version. He had an alternative argument. But, my lady, we say that the principle in law is correct, that even if the court would not believe an accused, the court can still find that his version is reasonably possibly true. But in this instance, the court rejected his version and said, I will now look at an alternative that's a mutual destructive version, if that's not reasonably possibly true. And we say the court erred, my lady. The court can only, with the utmost respect, evaluate the accused version as reasonably possibly true on his version, not, my lady, elect a different version, and then in the process, my lady, with the utmost respect, construct a different version. And we say that the court erred there. My lady, may I start? We will also, my lady, then, in our argument, deal with the conception and application of dolus evincialis as applied, my lady, in scenarios of error and objector. And we will indicate that in our respectful submission, the court erred. My lady, may I start? And I'm not going to read through my heads, but I will just touch on the Sekwe hurdle. Now, the Sekwe hurdle I deal with from page 34 of my heads. Paragraph 34. May I say at the outset, my lady, when I started with this application and when I was confronted with Sekwe, it struck me that Sekwe has been followed by our courts over a period of years. And when I evaluated Sekwe, my lady, I cannot understand that we followed Sekwe. Now, it was followed, my lady, I say, up until Basson, where where the Constitutional Court in Basson clearly indicated that Section 319 should be more widely interpreted and not only in instances where someone was acquitted. My lady, then, and I make mention and acknowledge the input by academics, my lady, because I've never claimed to be an academic, my lady, but I have, and I've acknowledge the assistance we received from Professor Grant. May I just take the court through our argument on Sekwe? Sekwe's main argument is, if the court would refer a question, reservation of a question to the appellate division, where an accused has been convicted of a competent verdict, the Court of Appeal would have only one option, and that is to make a finding that the case should be retried, which is clearly not correct. It's clearly not. It's not the only option available to this court. This court has discretion. Now, I find it, when I read it, and therefore, my lady, please allow me just to stand still and to share the insights I got, my lady. Now, in Sekwe refers to Ghani and says that in terms of Ghani, the only option available for a court of appeal would be to order that the accused is that there's a fresh trial. But a mere reading, my lady, of section 324, 3224, my lady. Sorry. And I deal with that at page 38. My lady, I've now run through the heads by saying that at page 38, paragraph 38, my lady, Sekwe refers to Ghani. Now, Ghani did not support Sekwe at all. Ghani clearly indicated that the court has a discretion, whereas the court in Sekwe accepted that the court has no option but to order a new trial if the Court of Appeal makes a finding that the court of quo wrongly decided the point of law. That is not true, my lady. And then when I read 3224, and I quoted there, the Court of Appeal may order that such of the steps referred to in section 324 be taken as the court may direct. Now, my lady, if one just take account of section 322 of the criminal procedure. The first thing, my lady, it indicates that, if I want to build my argument, Sekwe indicates that the court will have no option but to found that that there should be a new trial if the appeal court finds that the court of quo wrongly decided a point of law. They refer to Ghani, which clearly does not support that particular finding. A mere reading of 3224, my lady, does not support that interpretation at all. Because, my lady, at page 38, if I can ask the court to just turn the page, if the court sees that page 38, just turn the page, still paragraph 38, we say, respectfully submit that the court in Sekwe misread Ghani. The court in Ghani did not find that the only course open to a court under equivalent provisions of section 3224 was to order a retrial. It says that the court is not obliged in every case to order that such steps be taken, but without such an order, fresh proceedings in respect of the same offence could not be instituted. And then we say, my lady, an order in terms of section 3224 is a necessary order, but not a sufficient condition. It's a necessary condition for a fresh trial, but not a sufficient condition. My lady, and then what we then did is we just, because the question would now be, what can the court do? And we then read section 322. Now, 322, my lady, of the Criminal Procedure Act reads, in the case of an appeal against a conviction or of any question of law reserved, the Court of Appeal may allow the appeal if it thinks that the judgment of the trial court should be set aside on the grounds of a wrong decision of any question of law, or that any ground there was a failure of justice, or give such judgment that ought to have been given at the trial, or impose such punishment as ought to have been imposed by the trial. So there is an avenue open, my lady, which is not only a retrial. Now, my lady, if that is true, if our interpretation is correct, Sekwe should not be followed, my lady. But, my lady, we have to follow Sekwe because we say that the fact that the Court of Appeal would have no option but to order a new trial was the main obiter dictum of the decision in Sekwe. But, my lady, I got it. My lady, I'm not an academic, but I've got an academic next to me that will make sure that I use the correct terms. My lady, may I refer the court in Sekwe? It's a very Afrikaans decision. So I'll try and translate as far as I can. But I'll tell the court where I find this. At page 103, my lady, where Appellate Judge Rabi starts with, where he says, dit wil sê dat 'n herverhoor die enigste stap is wat die appelhof kan beveel. As daarmee rekening gehou word, kom dit heel onwaarskynlik voor dat die wetgewer sou gewil het dat so 'n stap gedoen kon word in 'n geval waar 'n beskuldigde inderdaad na verhoor skuldig bevind is. Maar lady, it's just what we said. The court said, because the Court of Appeal has no option but to order a retrial, it could never have been the intention of the legislature to have a retrial where somebody has been convicted of a lesser charge. But, my lady, we clearly said that is not applicable anymore. The court then, my lady, in Sekwe, dealt with the question, what is a competent verdict? In our case, what is count one? Now, in Sekwe, the court said that count one is in fact one charge with different possible results or convictions. But clearly that's not it. And there, this court was 100% correct. This court did not deal with count one as one charge with different possible convictions. This court dealt with count one as murder and other alternative counts. We're saying, my lady, that the Criminal Procedure Act, in listing competent verdicts, just made it easier for the state and for everybody to understand the law, and for the state not to have to, in every instance, indicate all the possible alternatives. Now there's an indictment, there's one count, we all understand what the alternatives to that one count of murder is. But this court was correct, my lady. This court acquitted the accused on murder. Whereas if it's one count with different possible convictions, this court would just have said guilty of culpable homicide on count one. But this court didn't. This court, in fact, acquitted the accused on count one and said instead, those were the words used by this court, instead he's convicted of culpable homicide. So, my lady, clearly, the understanding of the appeal court then about competent verdicts, my lady, we do it with the utmost respect, but you don't agree with. It cannot be one charge. Because, my lady, if one just has a look at what is there, if you charge somebody for murder, a competent verdict is public violence. Now that can't be one count, it can be an alternative. Now, if that is true, that we're dealing with one count, with possible different convictions, then, my lady, certainly the court can convict somebody of culpable homicide even if murder was proven. Because it's one count. But that can never be. If murder is proven by the state, the court is bound to convict somebody on the count of murder. It might be an academic result argument, my lady, but it is significant in evaluating Sekwe. Now, firstly, we say the first issue of Sekwe, we've given the court our understanding. The second one is understanding of competent verdict that wasn't shared by this court. The third issue dealt with is, and I'll read it in Afrikaans, my lady, and then do my utmost to translate it. 'n verdere oorweging wat myns insiens teen die gedagte spreek dat daar in geval soos die onderhawige herverhoor beveel kan word, is die volgende. Daar bestaan 'n skuldigbevinding. En die appelhof sou nie 'n herverhoor kon gelas nie tensy hy die bevoegdheid het om terselfdertyd die skuldigbevinding tersyde te stel. So, what it's saying is, because there's a conviction, the appeal court will not be able to even ascertain this appeal and or order a new trial without being in a position to set aside that one conviction. But it's neither here nor there. The accused was convicted of a lesser count. If the court in terms of 322 can give the decision that the court of should have given, that cannot be an issue, my lady, that would prevent this court from applying 319. My lady, the other aspect, and if I could just finalize my argument here, there is no appeal in Sekwe. If Sekwe is correct, if Sekwe indicates that not if Sekwe is correct, we're not appealing, my lady, the conviction of culpable homicide. We're appealing the acquittal on a point of law, on murder. So, my lady, the Court of Appeal would not have any reason to set aside, up until the time it makes a decision, the conviction of culpable homicide, because that is not what we're appealing. We're appealing, my lady, the acquittal on a conviction of murder. And, my lady, having read this in Sekwe, we then looked at 324, my lady. Where the court deals with the institution of proceedings de novo when conviction is set aside on appeal. Now, the section reads the following. Whenever conviction and sentence are set aside by the Court of Appeal on the grounds that, and it mentioned the grounds there. Again, my lady, clearly, Sekwe cannot be read into the provisions of the Criminal Procedure Act, where the Criminal Procedure Act indicates in 324 will only be applicable when a conviction and sentence are set aside. Then, my lady, I've now dealt with three issues as far as Sekwe is concerned. May I deal with the fourth? Fourth, my lady, is and I'll read it in Afrikaans again. Herverhoor gelas. Nou, let me start somewhere else. So vertolking hou die moontlikheid in dat in geval soos die onderhawige waar daar noodwendig heelwat tyd sal verloop van die tyd dat die verhoorhof die betrokke regsvraag voorbehou tot die tyd dat die saak in die appelhof verhoor kan word, 'n herverhoor gelas sou kan word nadat die beskuldige reeds 'n gedeelte van die vonnis of dalk die hele vonnis wat hom opgelê is uitgedien is. what the court's saying there is, because somebody's been convicted and sentenced, by the time the appeal is heard in the appeal court, the accused would have served a portion of his sentence. Well, but that happens with every appeal. And not only an appeal where the state appeals. I mean, that is part of the course, that if there's an appeal, the sentence, somebody would start serving. There's not, my lady, and when one evaluates this appeal, and specifically this point, there's not a counter-appeal by saying that the sentence is too harsh, that the accused would be entitled to a lesser sentence, or an appeal saying that the accused should have been acquitted. We don't have that. So for purposes of this appeal, this application, we don't have that. We only have the state appealing saying there should be, just because I don't have a better word, but a harsher sentence and a harsher conviction of murder. So, my lady, that particular point of Siekwe is with the utmost respect not convincing. Then, my lady, the point I just made is, the court said in the fifth instance that the court used, it says, 'n vreemde situasie wat ook sou kon ontstaan indien die staatse vertolking van artikel 3224 gelees met 324 juis is dat die appelhof gevra kan word om die herverhoor van 'n persoon te gelas terwyl daardie persoon appel teen sy skuldigbevinding aanteken. So that's just what I'm saying. If there was an appeal by the accused against his sentence or his conviction, the legislature would never have intended the state to appeal an acquittal. Lady, firstly, I don't think it's convincing, I said, with the utmost respect, and secondly, it's not applicable in this particular instance. But what is, however, interesting with what I just read is, in Siekwe, the court said one should take together and read section 322 and 324 together. Now, if one does that, it is clear that section 324 refers to when a conviction was set aside. Why I'm saying this, my lady, Siekwe say we are not allowed to appeal against a conviction on a competent verdict. We're saying, but then the court should never have referred to section 324 because section 324 clearly indicates whenever a conviction and sentence is set aside. And to read 322 4 together with 324 would be impossible. Because one just cannot do that. Because, my lady, why am I arguing this? 3224 reads, where a question of law has been reserved on the application of a prosecutor in the case of an acquittal, and the Court of Appeal has given a decision in favour of the prosecutor, the Court of Appeal may order that such of the steps referred to in section 324 be taken as the court may direct. And 324 clearly indicates, my lady, it's a conviction. My lady, then, that is only the first leg of the hurdle. My lady, I say it again. When I read Siekwe the first time, I could, there's one other point I'll make, but let me just carry on. When I read Siekwe the first time, I thought, but not only is it unfair to the state, which everybody would accept that if something is unfair to the state, it is, but it doesn't make sense. Because, my lady, if I, in this instance, and nothing prohibits the state to do that, if we charge the accused with murder and culpable homicide in the alternative, except for all these smiles and laughs we would have received, for having done that, it would have been absurd to say, if we did that, now, in terms of Sekwe, we had a right to appeal on the acquittal, on the main count, and so that would not have been a hurdle. So, lady, but what is interesting, I thought, but that must have been argued before. I can't be the first person that ever thought about that. And it was argued in Sekwe. But in Sekwe, the court said, I don't have to decide that. Which is, with the utmost respect, I criticize. Because that is the question. If there's a main count with alternatives, and somebody is acquitted on the main count and convicted of the alternatives, it just makes, with the utmost respect, so much sense that an appeal in terms of 319 against an acquittal would be no hurdle. But at page, well, it's almost at the end of the decision in Sekwe, court said, dis nie nodig om in te gaan op die vraag of dieselfde posisie geld in die geval waar iemand op 'n hoofaanklag en sekere alternatiewe aanklag tereg staan en hy dan op 'n alternatiewe aanklag skuldig bevind word nie. The court discussed it and said, I don't have to decide that fact. Lady, which is crucial. And if this court was correct in the court's approach to the conviction and the acquittal on murder, the hurdle in Sekwe would fall away. But, my lady, that's only one leg. The second leg is we had Bason, Constitutional Court. Now, my lady, in Bason, now, if one reads lady, it's indeed a pleasure to read Bason in the way that the Constitutional Court researched the history of Section 319 and how the Constitutional Court reached the finding that it did. May I continue? I've just interrupted myself. I apologize. What the court did there, taking into account Sekwe said, the state will only be able to appeal in terms of 319 upon an acquittal. The court said no, it cannot be. It could never have been the intention of the legislature. The court then took into account what duties the Constitution confers on the state as the authority to institute criminal proceedings, and the court dealt with the provision of the Constitution that the prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings.
What page are you reading?
It's at page 618. Well, although Bason seems a really long read, it's not, for purposes of this. The court can start reading Bason at 318. 618. At 619, my lady, what I read to the court is at the bottom. Also significant, my lady, is where the court said at 619 at D, one of the consequences of the advent of our constitutional democracy is the requirement that all laws must be construed in the light of the Constitution. This requirement flows from the supremacy of the Constitution. And then it says, my lady, that all old order legislation should be interpreted to be in line with the Constitution. The court then referred to the duties of the state in terms of prosecution, or in terms of the Constitution. And then, my lady, may I refer the court to page 620 at paragraph 145. It is plain from the legislative history of Section 319 that its purpose was, amongst others, to allow the state to appeal on a point of law by requesting reservation of a question of law. My lady, I'm looking for one specific may I proceed, my lady? As far as the important things is concerned, I'll get to that specific passage that I want to refer the court to. It carries on at page 621, where the court deals with the legislative history of Section 319, makes it clear that it was intended to afford the state the right to appeal a question of law to the SCA. This right is incidental to the right of the state to institute criminal proceedings provided for in Section 1792 of the Constitution. But the question is, was it intended that this right is available only in limited circumstances? It was then answered. There are indications in both the language of 3191 and in the context in which a section occurs that this was not the case. Section 3191 provides that if any question of law arises on a trial in a superior court, the court may, of its own motion, or at the request of the prosecutor or accused, reserve that question for consideration by the SCA. There is nothing in this language to suggest that the state may only request a reservation of questions directed at the conviction or acquittal of the accused. May I stress that, my lady? If the court would ask me, what is the most important thing in Basson? I'll say this one line. There is nothing, my lady, 621 at C. There is nothing in the language to suggest that the state may only request a reservation of questions directed at the conviction or acquittal of the accused. So, my lady, if that is taken into account, sequoia is irrelevant. Whatever sequoia thought about a conviction has become irrelevant by the way that the Constitutional Court interpreted Basson. Section 3192 indeed strongly suggests that the legislature intended to permit an appeal against any order upholding or dismissing an objection by way of a reservation of a question of law. Now, my lady, my argument is, why would the Constitutional Court refer to the interpretation in line with the Constitution, the duties of the state, and then say a question of law directed at either conviction or acquittal? Then, my lady, in fact, sequoia has become irrelevant. Then, my lady, may I then, whilst the court has it available, at page 622, my lady, at C, the court summarized its view of 319. In our view, Section 319 should not be construed so as to prevent an appeal against an order dismissing or upholding an exception. The section should be construed so as to allow the state or accused to appeal against an order upholding or dismissing an exception. Such construction of Section 319 brings it within constitutional bounds by recognizing the right of the state to institute criminal proceedings and, if need be, to appeal an adverse finding on a question of law. Not appeal an acquittal, appeal an adverse finding, which could be either acquittal or a conviction, because that's what it said. My lady, we then argue that our hurdle, as far as our right to appeal, because there was a conviction on a competent verdict, is not a hurdle anymore. But, my lady, may I say, and I say it with the utmost respect, my lady, I do not have to convince this court that I'm correct. I only have to convince this court, my lady, that there is a reasonable prospect of success, that the state may convince the SCA to hear this appeal, even when there was a conviction on a competent verdict. And that, my lady, with the utmost respect, we think has become clear. My lady, on the second hurdle, what's the time? On the second hurdle, my lady, we dealt with much earlier in our heads. The second hurdle, my lady, would be that the court will not refer a question or will not reserve a question of law for the SCA to deal with where it's mere academic and will not have any impact on the finding of the court. We say, my lady, that at paragraph 3 of our heads, my lady,